A lot of people don't know that before Christopher Columbus came here on behalf of the monarchy of Spain, there was also Muslim explorers that came here previous to that point in time. There's a historical record of Mansa Abu Bukhari, and he was the brother of the famous Mansa Musa. He had sailed to the west, which would be America, off the coast of Mali, the kingdom of Mali, and he took over 200 ships with him. We don't hear any more of his fleet going back to Mali. It's surmised some of them were lost at sea. But if you look at the Atlantic currents, the currents of the Atlantic Ocean, and it's been proven by a explorer by the name, I can't pronounce his last name, but his name is Thor the Hydro. I'm not saying it correctly, but he had used actually a type of boat that they would use at that time and was able to sail across the Atlantic Ocean using the current.
Hey, how you doing, everyone? Peace. This is Mansa from the Murakush Society, and we're streaming on three platforms tonight. We have some very special guests that are going to be discussing some things about the Moorish paradigm, sovereignty, sovereign citizens, history, or a lot of different things. So without further ado, I'm going to bring the guest on so we can get this discussion rolling. So we have Brother Isha, we have Brother Aemer, and then we have our friend and guest, Joe the lawyer. Okay, so I know there's a platform that's already laid out for this. So Isha, the floor is yours to get started.
Salam alaikum. I want to say peace and blessings to everyone listening to this. The subject of this discussion or this debate is in regards to a book that Joe the lawyer had wrote in regards to sovereign citizens, and he has a chapter in there discussing the Moors. I found a lot of factual information in that book that I did actually end up reading in regards to Moors. So I challenged him to a debate or discussion so we could get the truth versus the myth out in the open, and we could address all issues that has to deal with Moors. So the way the format's going to go, there's going to be a 5-minute introduction by both sides. There's going to be a 15-minute presentation. There'll be a 10-minute rebuttal, and then there'll be a 5-minute final word. So if you want to pass the mic to Joe, if you.
First of all, I'd like to thank you, gentlemen, for doing this with me. I do have this styled as a debate. I don't know if it's necessarily going to go that way. I would say I don't know which parts of the book you have particular issues with. I would be happy to discuss and defend any claims that I made, but I'll also say that I'm open-minded, and if you guys present facts to me that makes me think that what I wrote in there was incorrect or wrong, or perhaps be stated in a different way, I'd be happy to change the text in there. My issues are primarily with people who identify as sovereign citizens, whether that be Moorish sovereign citizens, white people who are sovereign citizens, black people who are sovereign citizens, Asian people who are sovereign citizens. I just identified in the book, there seems to be the sovereign citizen movement is large, right? And it encompasses a lot of different groups, in my opinion. There seems to be one strand that runs through that may be sovereign citizens and, Moorish temple adherents or Moorish nationals and kind of mixing. But that's where my issues lie. And I put a couple of things in my book addressing that. I'd be happy to talk it over.
Indeed. Appreciate your input, Joe the lawyer. Brother Aemer, do you have any opening remarks you want to make?
Yeah. I just wanted to say that one of the distinguishment I noticed coming from a lot of people discussing the sovereign citizen issue, and the more there's an emphasis on Moorish identity, whereas the other critics, you don't really get into the racial or ethnic identity of other sovereign citizens. And when that kind of happens, that actually walks on the line of racial discrimination, national origin discrimination. Whether you have a couple people who may identify as Moors that believe in sovereign citizen tactics is just not a justifiable ground to cast an entire ethnic group or national origin group as sovereign citizens. That's that's what I got to say about it.
Indeed, indeed. Appreciate your input, brother Aemer. I'm just going to introduce myself, and then we can get going with the format that you got laid out, brother Issa. I'm Mansa. I'm one of the co-founders of Murakush Society. Y'all can check us out at murakushsociety.org. Follow us on Facebook at Murakush Society, and you can follow us on Instagram at Murakush Society. So I'll allow everybody, whoever got to plug something in, to plug something in. I just had to get that going. But I just want to thank all of the guests today. Again, I want to thank Brother Issa. I want to thank Joe the lawyer, and I want to thank Aemer for coming on to the discussion. And what I have to say about it is, we know for a fact that the Posse Comitatus is the ones who started the sovereign citizens movement and ideology. And, the lawyer stated, and also similarly as Brother Aemer stated, there's a lot of different people who subscribe to different ideologies. So the Moorish ethnic group is diverse in religious thought, political thought, business thought, civil thought. It's a diversity of thought. So not all Moors subscribe to the sovereign citizen ideology. In fact, it's a small percentage that does. Although I think today's discussion, we may overlap into where some things are just right, some things are wrong, and then there's some gray area because of the technical legal discussion we may have. So without further ado, I'm going to bring everybody on, and we can go with the format that you have.
All right, Joe, you want to go first, or you want us to go first?
It doesn't really matter to me. I mean, I would, if you guys want to stick to the format, I'd be fine to stick to it. I almost feel like we would benefit more if we had a discussion. But if you want to stick to the format, that's fine. I mean,
It's up to the other members if we all agree unanimously on having a discussion rather than a debate. If now we go forward with the debate format.
if you want to stick to the debate format, I mean, I can say something for 5 minutes, or are we on the presentation part?
I mean,
All right.
personally, I wouldn't mind a discussion. I think the audience would get more out of a discussion. We'd be able to discuss more within the hour. That's just me personally. So I vote for a discussion as opposed to debate, but I'm fine either way.
I vote for the discussion.
We'll go
Guys,
with
I
a
want to make
discussion.
that it clear. We're not trying to defend any kind of sovereign citizen theory or ideology. So, a discussion is great, on my end.
Indeed.
All
Okay,
right.
so I guess we can start from the fact of Joe the lawyer. Could you explain to us what is your synopsis overall of sovereign citizens and Moors that you've seen interact as sovereign citizens or with the sovereign citizens ideology, or persons claiming to be Moors representing such ideology?
Sure. So generally, I think that sovereign citizenship in that ideology can be a problem. I recognize reading about, the Moorish Science Temple of America. I don't know as much as you gentlemen do. I understand that it's a much longer, tradition than even the sovereign citizen movement, right? If you go back and you look at Posse Comitatus and how the sovereign citizen movement came about, maybe gained popularity in the 1990s. And then at some point, there was a mixing of, I would say, sovereign citizens and the Moorish National Temple ideology. Now, I'm not saying, now, I honestly don't remember what I wrote in the book, and I don't have it in front of me. It is not my opinion that anybody who's associated with the Moorish Science Temple of America is also a sovereign citizen. It is also not my opinion that all sovereign citizens who are, let's say, of a darker skin, of an African American heritage, etc., are also associated with the Moorish Science Temple. So I recognize that distinction. What I have seen in a lot of the arguments that the sovereign citizens, where there's overlap, we have the sovereign citizens who also claim some association with the Moorish Science Temple of America. is, in my opinion, they make certain claims that I believe to be factually incorrect. I also may like, this is, I can't back down from this. I mean, I probably have criticisms of, some of the facts that the Moorish Science Temple of America may put forward. You guys may be able to clarify some of that for me. But, the sovereign citizens, what I've seen is they claim that, there was the treaty that was written between Morocco and the United States in 1777. Okay, so there's this treaty, and the Moorish sovereign citizens claim that this treaty makes them exempt from the law. And it's my opinion, from what I have viewed, that these individuals who argue that the treaty makes them exempt from American law, okay, also state that they are Moroccan in heritage and or from North Africa or the Levant, okay, and that this heritage is tied in to one of the elements that gives them immunity from American law. So that's why in the book, I do have a paragraph where I address race. Didn't mean, my intent is not to discriminate against anybody of a certain race, but I have seen these sovereign citizens claim that, they talk about the color of their skin. They tie that back to Morocco and North Africa, and maybe even further back to the Levant, to the Holy Land, to the Middle East. And I just believe that a lot of the people who are making these claims are likely not, and maybe I'm wrong about this, but are likely not genetically, connected to those areas. Now, I could be wrong about that, and I'm not backing that up with science. That is strictly speculation. But, if I think they are making claims, they're saying, look, I'm a darker skinned person. I am from Morocco. That's my heritage. And because of this treaty, I do not have to follow the American law. So that's why I tied that in my book. Let me just say, I recognize there are sovereign citizens who claim to be tied to the also the I guess the Moorish movement. I don't know. Maybe we need a name for sovereign citizens that are not part of the actual Moorish Science Temple of America. But I have seen them. There are, I don't know if they are white, but they're clearly not maybe of an African heritage. There appear to be some white members, some who are Middle Eastern, etc., etc. So that's why I tied that in. It's not my intent to discriminate against anybody based on race, but I brought it up because I believe that that is some of the argument that the sovereign citizens make, that I've seen them, many of them do this. I've seen them say, look, I am of a darker skin, therefore, the American laws can't apply to me. This treaty from 1787, what gives me diplomatic immunity? And they point to their own skin color as a reason that they are immune from the law. So that's why I bring that up in my book.
Appreciate that clarification. That was a very good, thorough, explanation into your perspective and, some of your points. I'm gonna go to Brother Aemer. Do you have anything you want to say in response, or positive, or corroborate?
No, not at the moment. I mean, that's an interesting interpretation, I guess. I mean, I personally haven't looked at maybe the arguments that he has maybe looked at. The whole the skin thing. I mean, I guess I can perceive it with a lot of the misconstrued notions and stuff that's floating around about Moorish identity and the history of Black Americans, African Americans, Moorish Americans, whatever you want to call them, is largely often misconstrued, and you know people are largely unaware of certain things. So I'm gonna go ahead and pass on that one.
Okay, Brother Issa, you have anything you want to say?
Yes, indeed. Yes, indeed. First and foremost, I want to make sure that Joe, the lawyer, and the audience knows that not all Moors are part of the Moorish Science Temple of America. Moorish Science Temple of America is one of the organizations that was formed in 1913, the early part of the 20th century. But it was there was already Moors in existence. Moors didn't come by the fact of a religious belief per se. Moors are descendants of who their forefathers were. Joe, I read in your book on the chapter, The Noble El Bey, you had stated, and I quote, one of the crazier things about this idea is that the vast majority of African Americans in the US likely have very little to no Moroccan ancestry at all. I want to stop right there on that point. I think first we have to define, what a Moor is. And according to the ancient, most ancient dictionaries in the English language, Moors were always considered to be the people of a darker hue, darker complexion, what people say black in a colloquial term, but of Northwest Africa. Now, it's not only we're not talking about the Kingdom of Morocco that was in 1956. We're talking about the ancient Moroccan Empire, which precedes that. And a lot of times the etymology, people want to go back to the Greek etymology of Moris, which means to be black or charred. However, there's an etymology in an older language than Greek that goes back to the Aramaic or the Phoenician, which means those of the West. And it has a specific etymology where it's dealing with the setting of the sun and how the darkness of the night sky comes in. That's the idea behind this word of Ma'arev in Hebrew, Maghreb in Arabic, or Mahurin in the ancient Phoenician language. So first and foremost, I want to set that out, that when we speak as Moors, we're speaking there's a racial context to Moor, there's also an ethnic context to Moor, and there's also a nationality context to the word Moor. And it's not just to the Kingdom of Morocco, but it's to all of Northwest Africa that was historically known as the land of the Moors, and at one point for 800 years to include Spain and Portugal as in Al-Andalus. So when we talk about Moors, we're connecting the ancient forefathers back to their descendants going to be in the Americas, the Western Hemisphere, not just particularly to the United States of America, but within the many lands that consist of North and South America and the Caribbean. So I wanted to put that out there first because that's a misunderstood subject. And when we talk about African Americans, this is a social construct it has no reality besides going back maybe like 30 or 40 years ago when it's popularized by Jesse Jackson, and it may have been mentioned before that. But when we're talking about Moors, we're talking about in the context of a racial context, we're talking in the context of ethnic context, we're talking in context as a nationality or those who have a national origin of being Moors.
Okay, appreciate that input, Brother Issa. I want to speak a little bit more directly to some of the stuff that you said, Joe the lawyer. So for starters, just to clarify some things, Moorish Science Temple as an organization, I'm not a member of the Moorish Science Temple of America. I'm not a member, but the Moorish Science Temple of America is not a sovereign citizen organization, and as an ideology, it doesn't subscribe to the sovereign citizen ideology. Okay, so that's for starters. I'm not a member of the Moorish Science Temple, but I can tell you for sure that as an organization, they're not. They're strictly religious. And what the thing is there are some members who were and maybe are members of the Moorish Science Temple who outside of that and their extracurricular perspectives of things may subscribe to sovereign citizen ideology. So I want to say that for starters. Secondly, in terms of when we speak about this treaty, so I'm just going to try to give you a quick, short 5-minute rundown on the nuts and bolts to the Moorish identity and those who subscribe to it generally. from a historical perspective and how that plays out in a legal perspective. All right. So for starters, when we talk about the element of the transatlantic slave trade in the African American population, the question is African Americans descendants of Moors, and not specifically Moroccans, because in the U.S. Dictionary of Races and People, this is on our website as well, we have a research tab that has a myriad of articles that break down all of the historical elements. But according to the U.S. Dictionary of Races and People, there's Moors and then there's Moroccans. So there's two different groups. Although Moroccans are descendants of Moors as well, they're not necessarily Moors in that context. So the question is, African Americans Moors. Now, there's a Negro Act, or it's called the Negro Law of the South. I believe it's 17. It's in the 1700s. If somebody on Aemer, other Issa, if y'all could pull the source real quick, it'd be great. If someone in the chat could pull it, just so we could show Joe the lawyer, so he knows we're not just making this stuff up. It says that the Negro, the definition of Negro, shall be confined to slave Africans, and then parentheses it says ancient Berbers and their descendants. Okay, and it says this doesn't include the Egyptians, free Moors, or Negro Asiatics such as the Lascars, right? So the name of this law was dealing with the rights, disabilities, etc. of the Negro. Okay, and it said that the Negro shall be confined to slaved Africans. So that means if you were enslaved, then you were, you took the identity of Negro according to this act. Okay. And it said that in parentheses, ancient Berbers. So when you look up Moors, it tells you they were Berbers. It tells you that Berber is one of the major ethnic origins or groups comprising Moors in its official definition. So that's a source from U.S. law that solidifies that. There's also the element of, so for example, right? You see how we have 50 states in the United States of America. So if you were to go to France or to England or to Spain, let's say someone lives in, New York. They when they go to these different countries, they're not gonna go and say that, oh, okay, I'm a New Yorker or I'm from New York. You're from the US. That's the international identity. The international identity is USA. The same structure that exists now existed before the colonial or colonization of Africa as far as jurisdictions. So my point to prove that is there's an ICJ case in which there's a discussion over the Western Sahara. Okay, the Western Sahara was in dispute with Spain or France and Morocco or something to that effect. And the International Court said that the Sultan of Morocco, his territorial jurisdiction extended as far as his religious suzerainty. We have that source and article as well. If anybody can, send me those, and I'll make sure before the show is over, before the discussion is over, I'll show our friend Joe here. The point is that what this case does is it establishes that the several jurisdictions that was in Africa where in which slave trading may have occurred, those local chiefs or kings didn't have the authority, just as a governor or a mayor or some kind of other elected official under the president doesn't have the authority to do, because the jurisdiction was with the Sultan of Morocco in terms of West Africa and Northern Africa. And there's also treaties that predate that between the British and the Sultan of Morocco It's in one of our books, Introduction to Moorish Treaties. It's a treaty, I believe, from that one right there. It's from 1714 or something to that effect. And that treaty, the sovereign of Britain recognizes the Sultan of Morocco as the ruler of all of West Africa. And the reason or the way Morocco became the ruler of all of West Africa is because it invaded the Songhai Empire, which sort of set things in motion for the transatlantic slave trade to take place. So my point is that when we discuss who Moors were historically, from a historical and a legal perspective, they were West Africans. And we know for a fact that maybe not as much to the degree that is said, but we know for a fact that there were human trafficking of West Africans, i.e., to the Americas. So my point is, there's also a point in history where we have Quincy, the president, John Quincy Adams, not John Quincy. I forget this president, but I know his name is, there's a Quincy or there's an Adams in there somewhere. But he actually freed Abdul Rahman, who was a slave, who was captured. He was enslaved and brought to America, but he was captured in Africa. He was from Timbo, and he wrote a letter to the Sultan of Morocco for his freedom. And the Sultan of Morocco interceded on his behalf with the U.S. president to get him free. So my point is this: whether I would not go and say that this treaty makes one exempt from American law, having a thorough understanding of U.S. law myself, it actually makes the Bill of Rights and the Constitution binding on a group of people who didn't have access to those rights being binding during slavery. You understand? Because there was an apology for slavery that took place in 2008. And one of the articles says by Congress put it out in 2008. And it says that whereas Africans were subjected to the indignities of being stripped of their names and heritage, being stripped of the name and heritage is the denationalization, is the taking away of the identity. And when we look back to the medieval era, all the way into the colonial era, before Negro and before Black and before these terms, which was created through legislation, similarly, which I brought up earlier, which is the Negro Law of South Carolina, which became one of the defining laws that defined and made Negro a statutory identity, which we know Black, colored, African American proceeds from. All right, so I just wanted to make a couple of those points, and I digress into anyone else who wants to elaborate on some things. But I just want to bring those things in the focus.
Can I?
Yes, absolutely.
So crap, I'm getting a little feedback. That's okay. Yeah, I think I can honestly agree with you with a lot of what you are saying, because what I was operating under, and I don't have the same understanding. I mean, I concede I do not have the same understanding of Moorish and or African history that you do. So I was operating, under the umbrella and the idea that Morocco is a specific Northwest African nation, right? Basically, the borders that we see today for Morocco. That's what I was operating under. And when I put my opinions on the book or on my show, and I did a little bit of research, and from what the research that I found, and look, I'm open to questioning any research, was that a majority of African Americans that are now in the United States were from more of like Southwest Africa, okay, based on the Atlantic slave trade, etc. So I was drawing the distinction in my mind that a majority of African Americans in the United States come from this Southwest African region. And then you have this more Northwest African region that is Morocco. So I drew a conclusion based on, I acknowledge imperfect information, but just the information that I had, that, a majority of African Americans in the United States are not, of Moroccan. Now, what you're saying, and I have no reason to rebut this, and I agree with you. Look, we have national identities, ethnic identities, racial identities. Really at the end of the day, we could blow it all up. All right. I don't deny all that. But you're expanding that territory. And based on what you told me about history, I have no reason to deny that. And what you just told me sounds eminently reasonable that, the Sultan of Morocco at points of time had more or less a lot of power over all of West Africa. There were prior empires and subsequent empires that covered much larger territorial regions that exist today. And I really don't deny that. What my argument would be, and I have a few more points I want to add though, is that Morocco at the time of the treaty was, this, okay, A, B, C, and D. And therefore, I thought it was a little bit outside the realms of logic for all, African Americans to claim some sort of Moroccan heritage. Now, but based on what you're saying, sir, it's eminently reasonable. And, I can do that with, my own history or ethnic heritage, right? I'm majority of Italian heritage, right? And, people who are from Europe tend to adopt, all of Europe as part of their heritage, right? And the same can be said as other parts of the world, even though, Southern Italy probably really has nothing to do with what happened in, Finland or Norway or Scotland. So I'm really not opposed to expanding the definition of more, but that's not the definition that I was operating under when I was talking about the treaty, etc. I would say too, I'm I'm of Sicilian and Southern Italian heritage. There were points in time where Southern Italy and Sicily were under North African rule. And in fact, vice versa, if you go back far enough, the Roman Empire, etc. So, and you can see, I
Here's
sort of
the
have a
thing. I don't want to cut you off because you're touching on
okay.
some key points here that I think is great for the audience. But what I wanted to touch on real quick based on what you said is, see, when we talk about how national identity, when we see the reason why this identity discussion is so important for those who are labeled African Americans is because, like I said, in article for that one article for the apology of slavery that says, whereas Africans were subjected to the indignities of being stripped of their names and heritage, we know for a fact that every group has been subjected to some form of slavery in history. We're not the only group that have gone through slavery, you see? So that's not nothing special there. The significance is that everyone else wasn't stripped of their identity when they were enslaved. So you have something in Roman law, because U.S. law goes back to English law, then it goes back to Roman law. There's capitis diminutia. So there's capitis diminutia minimum, medium, and maximum. And maximum is the complete stripping of all heritage, names, titles, inheritances, and everything. You see? So this is why when we, as those who are labeled African Americans, have the identity of more, that means we had to research so that we can be a part of having a national origin and an ethnic identity. And when, people flip flop on how they choose to address Africa. A lot of times when people address Africa, they say Africa like it's a country, when it's 50 plus countries on that continent. So when we address it in that way, we look at it as a whole. But then when we look at it to certify certain things, we like to split it up. See, the jurisdictions of today didn't exist in the early founding of America. But I'm pretty sure when you go to Florida and you go to some of the state heritage museums and different things like that, you're going to find information that the Spanish left when they had territories there and what the indigenous people, what they had there. You're going to find that as a part of Florida's heritage. You're going to find French heritage in Louisiana in the state records and those types of things. So what we see today, the modern nation states was created with the founding of the United States of America. And then that became the popular form of government to create. So when we start to look at how these governments and these things formed, we have to look at how jurisdictions operated. So the reason I brought up that ICJ case was because at the time of the enslavement of these people from West Africa, southwestern regions, as well as the pure western regions, and before the slave trade, before the 1400s, before 1441, most slaves or most enslaved Africans came from North Africa. They came from places like Morocco because the Portuguese, the British, and the French had already been raiding Moroccan towns and enslaving them. You see, so they were already a part of the early aspects of the slave trade. It wasn't until later aspects of later days of the slave trade that the slaves would come from the southern parts like the Ivory Coast, Nigeria, what's currently called Nigeria, and all of those African states were formed in the 1960s. So those borders are fairly new. So my only point in just bringing this up is that at the time of the capturing of these people who we're calling African Americans, they were part of a jurisdiction, a government, a sovereign government, where they were known internationally as Moors. Just like if the United States fell today, and everybody still had their U.S. passports, they'll be saying, I'm from what formerly was. Now, I'm not saying the jurisdictions that existed didn't exist today, but when we have to find, identify, and date these people who are called African Americans, who we know have been stripped of their names and heritage, when we look in the law books, that's where we find it. So I just wanted to put that out, and I digress. Is it Ilamir? You have anything you want to say?
Yeah. I just wanted to point out that when it comes to the Atlantic slave trade, that part you brought up about the raids on the coast of Morocco, the Portuguese conquered 5 cities in Morocco in the 1400s and depopulated them. That's well documented. Those people were shipped to Lisbon and ultimately sold to Spaniards who were colonizing in the Americas. So from the early 1400s to the late 1500s, the majority of quote unquote African slaves were coming from North Africa. So I just wanted to throw that in there. I can
Indeed.
drop some sources in the link, but I put up the links that you was asking about earlier, for reference points. The 1790 Negro Act, the U.S. Dictionary of Races and Peoples. They in the private chat side group.
Okay. So
Digress.
what I'll do is I'm going to pull those up. Y'all can discuss it, but I'll get those ready, and so I'll be able to show Joe, so he'll know that we're not just making that stuff up. Some of the stuff that we reference. Is there anything you want to say, brother Issa?
Sure. Yeah, just to add on, when you was talking about Prince Abdul Rahman, who was free, there's also another case called they call it the Sundry Free Moors of South Carolina, and it goes to show that there was a body politic in this country who identified specifically as Moors, and even in Georgia Code Annotated, they also have a section in there where they deal with the Moors, who were part of the body politic in Georgia at the time. So what I'm saying is that we've always had a continuity of a body politic of people identified as Moors in this country, preceding the establishment of the United States of America. That body politic of Moors existed in various parts of this country. A lot of people want to start off with Christopher Columbus, but a lot of people don't know that before Christopher Columbus came here on behalf of the monarchy of Spain, there was also Muslim explorers that came here previous to that point in time. There's a historical record of Mansa Abu Bukhari, and he was the brother of the famous Mansa Musa. He had sailed to the west, which would be America, off the coast of Mali, the kingdom of Mali, and he took over 200 ships with him. I estimate at a small, trying to be at a small estimate of how many men could fit on the ship. I would estimate 10 per ship, which would give you a number of 20,000. Having said that, we don't hear any more of his fleet going back to Mali. It's surmised some of them were lost at sea. But if you look at the Atlantic currents, the currents of the Atlantic Ocean, and it's been proven by a explorer by the name, I can't pronounce his last name, but his name is Thor the Hydro. I'm not saying it correctly, but he had used actually a type of boat that they would use at that time and was able to sail across the Atlantic Ocean using the current. And we have evidence when you want to talk about DNA, because I know you mentioned that in your book. You had mentioned it in a chapter about DNA. A lot of times with DNA, when you catalog the DNA, the person who indexes and catalogs the DNA is going off the assumption or the premise that they have in their head of history in order to index it. They're using living beings and grouping them by haplogroup living beings to establish a catalog. But many people within the Caribbean and also within Americas, in the DNA test that they have taken, it shows a strong presence of Malian grouping of DNA. The assumption is this came through transatlantic slavery because that's the premise that everyone's working off, that this is the only way that people of African descent came over here. A lot of people not working off an assumption or a premise that, wait a minute, there was actually explorers who came from that part of Africa to this country or this continent before the arrival of Christopher Columbus. I just wanted to add that part in there because it goes directly to something you said in your book.
Also, I want to put something out there as well, just to clarify for Joe the significance of all of it, just the significance of the Moorish paradigm. So, undoubtedly there's a racial discrimination issue in the country, and that leads to a lot of frustration on a lot of different sides. The thing about the African Americans that has to be understood is, and many of them don't even understand this. Many of them don't even, I mean, there's people with PhDs, they have big time degrees and still don't understand this basic thing. This basic thing is that, uh, so in the effort of finding a solution for racial discrimination, other groups like Italians, they weren't initially classified as white when they got here. They didn't get white status. A lot of Middle Easterners didn't get white status. A lot of different groups didn't get white status right away when they first got here. It happened over decades, as these immigrant groups rose in class and in income levels. Like, so Federal Directive 15 is the federal guidelines for racial classification in this country. So for white, it says anyone having origins in the original peoples of Europe, North Africa, and the Middle East. For Asians, for American Indians, it says anyone having origins in the original peoples of North, Central, and South America. For Asians, it said the same thing. For Hispanics, it don't say that. It just references the culture of the Spanish culture. But for Black, it says anyone having origins in the Black racial groups of Africa. Clearly that's not having origins in the original peoples of Africa. That's saying if you have origins in the Black racial groups of Africa. Completely different language. But what that means, what Black racial groups of Africa means is, that means it's a slave group. So along with the enslavement came the stripping of the name, the heritage, and the identity. So when we look at Moor as an identity that attaches a people to a land and a nation, right? Because the current kingdom of Morocco didn't become the current kingdom of Morocco until 1956, when they got the independence from France, 1956, 1957. So they inherited the treaties and things that came from governments earlier, before it. This is why they make trade agreements, because trade agreements is what they're able to make with the United States, because that treaty secures trade and commerce with them. So I disagree with the assertion that by having a skin complexion makes you exempt from U.S. law based on having a treaty with Morocco. You see, because the reality is, yeah, so I disagree with that assumption, that assertion that you made that other Moors made, that this treaty means I'm exempt and immune from U.S. law when we're talking about the operation and construction of the law, because we know in Article 6, and Obama argued this, in Article 6 of the Constitution, not saying he was right, but, and we know that the courts have a different opinion of some of these things as well, but as we all know, at least some of us are clear that there's a lot of racial discrimination in the judicial system as well. But the bottom line is that this particular treaty, what it establishes is that it's a part of domestic U.S. law because it's been ratified by Congress, okay? So a self-executing treaty means that it doesn't need a foreign government to invoke it. It's binding on the citizens of that land or that country because it's been ratified into law by Congress. And that's what they did with these treaties that they made with the Sultan of Morocco and the early founding of America. So that's very significant because what that does is it makes it a part of U.S. law. You see, it's not separate from U.S. law, it's a part of federal law. You see? So what that also does is that it gives access to the people who are rightfully, quote unquote, Moors, the ability to gain the rights secured by those treaties, which the U.S. Constitution secures agreements made in treaties. You got to understand that in the early founding of America, when they was legislating the Negro identity, they were stripping the identity, therefore stripping rights and immunities that came with it, because in that Negro law, it said that Negroes shall be confined to slave Africans, doesn't include Egyptians or free Moors, because we have examples in U.S. law where free Moors were able to, gain the benefits and the rights that Negroes didn't have. Because what was being created with Negro was the legislation of an identity, of creating a straw man, essentially. So my point is that this treaty gave otherwise people you would name Negroes access to the rights guaranteed by the Constitution that wasn't available at the time. Because when they were freeing these quote unquote Negroes, the discussions that the Congress had and the judiciary had was that we can't give these rights like we freed them. Negro, they're free now, but free is not a status in law. We can't give them rights that they didn't have prior to the enslavement. And Negroes didn't have rights because they created that through legislation. These people were descendants internationally known through international treaty as Moors. That's who they were. When you look up the 1800 definition, the early definitions of Moor in the Webster's dictionary, it'll tell you that Moor means Negro, black man, blackie. That's what it says. So I just wanted to, hopefully I clarify why it's significant in terms of the identity to people who are mislabeled African American or black, because nobody else has, like, we know that race is the social construct, but the skin complexion through slavery became the way they attach the racial identity that's a social construct to actual skin complexion. You understand? Which, and that in itself is prohibited by the 13th Amendment, which is considered a badge of slavery. So I just digress there. But what I want to do before I completely digress is just show you some of these sources that that will.
Yeah, I just want to chime in and add that there are provisions in those treaties that prohibit slavery, in terms of Moors and any treaty parties that they, you know, had treaties with. And these same type of provisions is found in the British treaties. They're found in the treaties with the French. They're found in the treaties with the Spaniards. So that that's something else to add in there. And one of the other things is that they guarantee equal justice. We don't often see that with the current judiciary, but that form of legislation guarantees equal justice.
If I may, so I agree, overall, when you really think about race and identity, it is there's a large aspect of it which is socially constructed. Number two, the thrust of my arguments and I did bring up, the what based on the research I did, what I thought Amor was. Okay. And I'm open to accepting different definitions of what a Moor is, right? Like an expanded definition of what a Moor is fine. All of West Africa and or North Africa, that's fine. I don't, we could debate about that all day long. We could go back and forth. We could move further, like you said, into parts of Spain, parts of Italy, parts of the Middle East, etc. I mean, you could do this with most races or ethnic groups. You could make arguments that expand it and you can make arguments that shrink it. I also want to say, I recognize, just to be clear, I believe racism is a big problem in the United States, and that it within the justice system itself there are huge issues that have to do with racism, and we all need to do things to change that. I just want to put that out there. I wasn't trying to discriminate in any way, but what my argument is, and I mentioned this at the beginning, is I've seen sovereign citizens or individuals in these videos claim, again, make claims that this treaty somehow gives them immunity, and then they tie that back to their own racial heritage. Okay. And if somebody's going to make claims that the laws of the country that they live in don't apply to them and that their race is one of the reasons for that, I think that opens it up to fair criticism. So that's what I was doing. Ultimately, and I would say, like, I love Mediterranean history overall, right? Like the Roman, North Africa, everything, Hannibal, like I love those portions of history. I just want to put that out there. But I don't think the treaty that you got, gentlemen, referenced, or any of the other treaties that may be out there, gives anybody in the United States any special status under the law. And I have read the treaty. I have read the Treaty of 1787. I haven't read the other treaties that you gentlemen are referencing, but it's my position that that treaty doesn't give anybody any special rights. And I recognize that, African Americans, a lot of people were denied, when they say the words of the Constitution, the words of the Declaration of Independence. Well, yeah, those rights only applied to landed white males at that period in time. And you're absolutely right that other groups have been. I mean, there's documented cases of discrimination against Italian Americans, etc. But I don't believe that treaty gives, at the time that it was executed in 1787, or all the way up to the present day, gives anybody any special rights. And I recognize what you said, sir, that a treaty is law. A treaty does, once it's executed, it is federal law. So I'm not arguing over the operate. I don't think we have to have an argument over the operation of the treaty. I think that maybe I'm not sure if this is what you meant and what you just said. If anything, the argument is over the content of the language of the treaty itself. And my reading of the content of the treaty, in my opinion, it doesn't grant anybody any special rights under U.S. law. That's just my opinion.
Yeah, I got a few words to say about that. You got anything you want to say about that, Aemer, before I?
Well, I mean, I just said it a minute ago. They all guarantee equal justice. I mean, we can go into what is equal justice. Equal justice is due process and equal protection under the law. So it's not special per se, but it's statutory, where we got these same rights under the federal constitution and they're constitutional, but these treaties supersede the Constitution. In other words, when they made these treaties in 1786, they don't come out with the first 7 articles for the United States Constitution until about 6 months later that year, or 1787 per se. It's around the same time. Why is that significant for us as what you would call African Americans per se? That's significant for us because for decades we have found legal arguments alleging that we had no rights under the law during these periods. But that's just incorrect. And even if you go into any other treaties with Great Britain, it's the same thing. Equal justice is guaranteed, freedom of religion is guaranteed, privileges and immunities, some of the same things you're going to find in our constitution. So that, that's pretty much what I would say about it.
Yeah, what I would say is, yeah, I agree with what Aemer said, and I agree with when you say that it doesn't give anyone any special rights. Okay, so it may not be special to those who have the white status in the U.S. Society, in the U.S. government, because they got the federal racial classification. It's been well established through U.S. case law that black means criminal, it means slave, and the way the law is enforced is disproportionately enforced against those who have the racial status of black, the social construct. So when we talk about special rights, it's special in that way. And then we also found that it's been because these same rights that we're discussing about equal justice is not something that's is available still. Some may get it sparsely here and there, but it's something that's still not readily and plentifully available to those with the black racial status. It's just a fact, even when we look at the data and the stats. So when we talk about also is it being special, I think what we and you can correct me if I'm wrong, the heart of that is this treaty doesn't give you the right to openly break U.S. law and then claim that there's no jurisdiction to prosecute you for openly breaking the law. Am I correct? Is that what the heart of when you're saying the special rights?
Yeah, I guess that's probably not the right language. I would argue yeah, I mean, what you just said is what I was trying to say. I would argue this treaty doesn't allow anyone to be excluded from United States law, whether it's state law or federal law. And I've found that that's the argument that some sovereign citizens who may also identify as Moors will make, that this allows them to be excluded from federal law.
From a general standpoint, and I'm sure you would agree, treaties generally are superior to state laws. Now, this is not in support of the sovereign citizen guys who are arguing these things, but just generally, a treaty supersedes state law because it's federal law.
Yes,
Um,
I agree.
the other thing I find it interesting, I don't know if you've ever come across the ICJ case, France, Morocco versus United States of America from 1952, I think it was. But in that case, it's very peculiar because there were U.S. citizens in Morocco making these types of claims when they were breaking laws in Morocco. And that entire case is all about that. I can drop a link on that in the chat. Take a look at that.
I would argue that they're incorrect as well. And that's just, and again, I'm not arguing the operation of treaties. You're correct that I agree with the opinion that a treaty can override state law if that's what the language of the treaty purports to do. But my argument is not over the power of a treaty or the status of a treaty within United States law. My argument is that the content of the Treaty of 1787 doesn't attempt to override any state or federal law. It lays out a relationship with the United States, but it doesn't have any effect on any individuals or actors more or less in the United States that allows them to exclude themselves from law. That's my argument. What if part of what you're saying is that the Treaty of 1787, and given the history of African Americans in the United States, that it actually has a significance historically? I agree with you. I believe that it does. And I would never oppose to it actually being, I wouldn't even oppose it being cited in the correct context as some sort of persuasive authority to show, what the government was trying to do, or that there was a treaty of amity between these two countries 300 years ago, when highlighting the history of the United States and or Morocco. But my opposition to it is that the treaty does not do anything to exclude anyone who's in the United States from any laws. And that's based on the content, not on the actual operation of a treaty itself. A treaty, yes, if a treaty is approved by Congress and put into law, I studied it more in depth in the past. You're right. It has the power of federal law. It would override state laws. So if the United States did sign some sort of treaty that in the content of the treaty itself purported to give certain citizens in the United States special powers, that could be the case. But I don't believe that this treaty was intended to do that or does that. That's my stance essentially.
Well, okay, you want to say something, bro?
I want to get
Then I'll say something,
yeah.
and then we can.
I'm just going to suggest that you read the RCJ 1952 case, because they talk about this particular treaty as well as several other ones, and they discuss that they discuss their connection. So there may be certain clauses that are in treaties with Great Britain and the Sultan of Morocco that covered this area of what we call the United States, or the 13 colonies when it was under British control, um, that are related to the treaties that the United States indeed enter into. So to get a better perspective, you'd actually have to read those. And then you would also have to look at how treaties function under Islamic law. That's a whole nother aspect. But I'm a digress.
You want to say something, brother Issa, and then I'll take the floor.
Yeah, I want to add on to the whole treaty aspect. There's more than one treaty. A lot of people focus it on a treaty of 1786, the treaty with Morocco, July 15, 1786. But we have, I think Aemer had mentioned the previous treaties with Britain, and in this country, those treaties come into as common law, the United States of America. One of the things I want to bring up,
It would be British statutory law,
yeah,
because the crown ratified them. So yeah.
but one of the things I want to bring up in the particular treaty that you're talking about is, and one of the things with these treaties, they're written in English. This one right here, in order to get the proper interpretation of it, we'd have to read in Arabic. I could read Arabic, but we'd have to look at the Arabic treaty for what was the original intent on the Moroccan side of it. But from the English that we all familiar to read English here, I think some of the points that you bring up about some of these, I don't want to call them sovereign citizen Moors, because if they've never said out their own mouth they're a sovereign citizen Moor, I don't want to put that appellation on them. I think a lot of times other people describe them as such. I've never personally heard anyone who declares himself to be a Moor call himself a sovereign citizen. I've heard other people describe them as such. So I'm not going to do that. But one of the things with people who state that they're a Moor, and if they're claiming that they have diplomatic immunity, so to speak, and they claim it off a treaty, I wouldn't agree with any form of diplomatic immunity. But I would say that these treaties do have an effect on Moors today in America through just sanguis. If my family is descended from Moors and this treaty applies to Moors via the doctrine just sanguis by blood right, I have standing to this treaty because I am a Moor. Now, one of the things in the treaty itself, I think if you go to article number 6, I think many of the people who make some type of claim in regards to the treaty, that's one of the articles that they're speaking about. And it says in part, if any more shall bring citizens of the United States or their effects to his majesty, the citizens shall immediately be set at liberty and effects restored in like manner. If any more not subject to these dominions shall make prize to any of the citizens of America or their effects, bring them to any ports of his majesty, they shall be immediately released. Now, I'm reading the English, and that's all we have in front of us right now. But even just reading that little part right there, it's speaking about a special class of people, or more, and citizens of the United States. So there was relations that if we were going, I'll give you an example. If you, as an American citizen, had traveled to the ports of the kingdom or the dominions of Morocco, the Sultan of Morocco, you have a status that they have to respect your status as a treaty, somebody who's subject to a treaty. Same way as a Moor, they have that same status that somebody who's subject to a treaty that affects Moors, they have standing on it. That's one of the points I want to bring up. I'm not saying it gives you a right to kill or murder and get away with any type of crime, because if you read in a succeeding article of the said treaty, it's Article 21. You go to Article 21, and this is what Aemer had spoke about. It says that if a citizen of the United States should kill or wound a Moor, or on the contrary, if a Moor shall kill or wound a citizen of the United States, the law of the country shall take place and equal justice shall be rendered. The counsel assisting at the trial, and if any delinquent shall make his escape, the counsel shall not be answerable for him in any manner whatever. So we do see that, yeah, Moors have to obey the laws of the land, but they specifically say they have equal justice that's supposed to be rendered to them and assistance of counsel. In regards to that treaty, that's what I wanted to add on in respect to that.
All right. Also, what I wanted to add on is speaking a little bit more directly to what you had stated, Joe the lawyer, in terms of it not being special rights, and the actual language of the treaty doesn't confer any special immunity from you or exemption from U.S. law. First, I just want to say I agree with that within a certain context. The treaty was establishing the relations that they were going to have. And in fact, in Islamic law, that treaty is considered a grant because it was something that was given to the United States. And when it talks about in Article 21, because see, here's the thing, that 1786 treaty expired. So they went to get another treaty with his son. And he said, I can't redo one that my father, did. He just reiterated the same articles, sealed it, and then that one has the perpetuity clause, every 50 years clause. So that's the one that's actually still in effect, and both of them have been ratified by Congress. But my point is, in the construction and discussion of it, it discusses how jurisdiction is supposed to take place. When it talks about if a Moor shall kill or wound a citizen, or if a citizen shall kill or wound a Moor, that could be physically, that could be commercially, or commercial injury, you know what I mean? A financial injury, something to that effect. And it talks about what law is supposed to govern them. In the U.S. translation, it says the law of the country. In the Arabic, it says the sacred Mohammedan law, or it says the Islamic law. So whether those points of argument is not the point I'm getting to. What I'm getting to is that this particular treaty has an effect on, first, like you said, the historical aspect on an identity level, but it also has a legal effect because, again, when we talk about what an African American is or what a Black person is, we know this is a slave criminal identity created through statute and legislation based on a people being stripped of their names and heritage and their identity. So it's just like Native Americans. Native Americans are always citing they're always citing their treaties that discuss certain rights and privileges that they have in relation to the United States. They never use those treaties to say that they're exempt or that they're immune somehow, but it does confer special rights because, just like Issa brought up, when you're dealing with passports and going to different countries, not every country, the U.S. passport can get you into a lot of different countries. Okay, there's certain countries that the U.S. is in good relations with that you can go to their country and they can come here without a visa. You see, like Canada and the United States, they're on such good terms that you can go to Canada without a visa and a Canadian can come to the United States without a visa. But that's not the case for some other countries. So not all rights, there's basic rights that's preserved in the Constitution that governs everybody. And those rights that are governed in the Constitution actually protect and secure rights that pre-existed. So the Constitution itself doesn't actually confer any rights itself. It secures and guarantees pre-existing rights or unalienable rights. Also included among those rights are treaty rights, because Article 6 specifically says that treaties are part of the land and shall be binding, made before the adoption of this Constitution, which that particular one was. So when we talk about special rights, I differ somewhat, but I don't differ to the point where I'm saying that it confers rights that immunes one instinctively from prosecution. Maybe malicious prosecution. It protects you from a malicious prosecution, an abusive process, which are things that are violation in and of itself when it comes to court rules and it comes to statutes and things like that. But the other element and the other aspect is that when we talk about jurisdiction, and when you even dig into the court rules of every courthouse in this country, that has court rules based on the federal civil rules of procedure and the federal criminal rules of procedure, uh, they all they all say in there that jurisdiction is something that could be challenged at any time. And challenging jurisdiction, because it's something that could be raised at any time, whether that's pre-trial, during trial, after trial, it can always be challenged. Okay, and we know that the basis for jurisdiction is persona, and it's also subject matter jurisdiction. So they have to have jurisdiction over the person, and they have to have jurisdiction over the subject matter at hand. So based on, these two components would give a court of competent jurisdiction the jurisdiction to try or hear a matter. So when we start to talk about the person, and if a particular court has jurisdiction over them based on what statuses that they have. Because when I gave you I can pull it back up, but the whole thing with the Negro Act, it discusses the status, rights, and disabilities. So there's disabilities that come along with the Black identity that is not inherent in the Moorish identity. So it does have elements of special rights in it that does give one a position of favorability over the other status. But and my final point I want to make is, again, when you're discussing the roots and discussion of legal controversy, whether that's someone challenging jurisdiction or challenging some kind of law that's unconstitutional, the treaty for Moors does become a basis that can be used by law to substantiate what rights are available to this particular person that are secured by the Constitution. So, for instance, in one of the articles of the treaty, it discusses specifically, I think it's the ship signals agreement. Whereas if these two meet at sea, they shall not be molested. That's basically no search and seizure clause in that particular treaty. That also exists in the Constitution. But the Constitution is only rendering the equal justice that treaty says is supposed to be rendered when there's matters of controversy between these two parties. So equal justice is also something that's protected by the 14th Amendment. So there's multiple constitutional amendments that protect pre-existing rights before it. So I think when we have the discussion of does this treaty confer special rights, I say it does confer special rights, but it doesn't confer rights that says one is immune from criminal prosecution.
I mean, most of the actual research discussion on it point out that the rights are essentially the rights that most people consider to be white are often enjoying. So, like you said, in that context where quote unquote Black Americans have often been denied due process and equal protection under the law, quote, equal justice, however you want to slice it up. That would, in a sense, kind of look special. But one thing I want to point out before I digress is that several of the British treaties with Morocco guaranteed um, jury rights and religious freedom and other things like that that are also relevant to the treaty with the United States because of the favorite nation clause. There's a favorite nation clause in that treaty, and that is the function of a favorite nation clause is to tie itself to other related treaties. But one of the things is that they guaranteed that there would be Moors on their juries. So here we are in modern times, like you've already agreed, there's a racial problem within the justice system. The whole jury of your peers and things of that nature. So if you're prosecuting Moors and there are no Moors on these juries, I would argue that that's a violation of that particular provision that secures a Moor that right. Oh, but that's me. But I wouldn't consider that to be a sovereign citizen theory because it's actually written within the treaty legislations.
That's fair enough, gentlemen. I just want to say one more thing. We're gonna have to agree to disagree, probably, especially with what I'm about to say. This is gone. So I'm gonna say this, and then you guys can have your answer, and then I gotta go. It's 9:30 here. So my argument would be that, and this is a sort of a legal interpretation argument, is I think that you would have to go back to the time that this treaty was written, and you would have to determine what the intent was of the parties who signed into this treaty. And my argument would be that the word more is used in the treaty. My argument, and this is from likely the interpretation of most treaties, is that they are only referring, okay, the United States in this treaty and likely the Moroccan kingdom at the time, they are only referring to the current people of Morocco. That my argument is that therefore this treaty, even if it did confer some sort of special status, it only applies to people who were citizens of Morocco at that time, which I would argue is a smaller geographic area and likely would not apply to the vast majority, if not all, of African Americans who eventually came to reside in the United States. So you guys are, your argument is they use the language of more, therefore it applies to anybody of African heritage within the United States. I don't want to mischaracterize it, but I feel like that's what I'm hearing. Because they use the language more, it should apply to anyone of African or Moorish heritage that is currently in the United States or was in the United States. I would argue that was not the intent, that this treaty was intended to apply to Moorish citizens in the country of Morocco and the United States. So I also think I don't, whether we can argue some sort of special status, but again, I don't think that it transforms or changes the rights of anybody who was in America at the time or an American citizen, more or less. As far as the Islamic or the Arabic interpretation, I don't know what it says. I have no reason to disagree with you that the Arabic interpretation may be different from the English interpretation. But if the United States didn't intend the meaning of that Arabic interpretation, then it's not going to be the law in the United States. If anything, the Supreme Court who interprets the law in this country would likely just say that portion is invalid. And so you could see this in contracts, the contracts that are made between people in the United States and other countries, and the languages have different meaning, et cetera, et cetera. Well, that's up to a court to determine whether or not that other meaning is, which meaning is right or which meaning is wrong. But if one party didn't intend that meaning, then there is no meeting of the minds. And if there's no meeting of the minds, there's no agreement. It's null and void. That's basic contract law. So that's my argument. I believe that this treaty, it basically outlined relations between the United States and Morocco in, in the foreign relations area because there were issues as far as piracy and shipping in the Mediterranean and around the shores of Africa. The intent of this treaty was to solve those issues. It actually is very interesting that this treaty was renewed over and over, and that, this is, I believe, the oldest treaty that the United States signed with a foreign power. I think that that's pretty cool, but again, I don't. And even if it did confer some rights of due process and or the privileges and immunities of that the Constitution currently does, like, that's neat, but that's essentially a historical artifact at this point because the United States Constitution now grants that to any United States citizen at this point in time. So that it's essentially a moot point. But before, because I'm gonna hop out. You guys, I know you want to rebut what I just said, and that's fine. I'm gonna stick around for that. But I just want to say thank you for doing this with me. I appreciate this opportunity. I actually learned a lot here. I'm gonna read. If you guys send me that ICJ case, I'm actually very interested to read that. I did not have all the I don't have all the historical context as far as treaties with Britain or all the subsequent relations. That ICJ case does sound interesting. I took international law when I was in law school. I'm familiar with the international, the International Court of Justice, the International Criminal Courts. So I'd be happy to read.
Yeah, they discussed the intent of the treaties in that case, so that's something you definitely want to check out.
Yeah, and the reason he's bringing that up and the reason he's saying that it discusses the intent, just to drive it home a little bit more, is because it discusses the actual ways in which it was applied. So I'm not sure your opinion would change after reading it, but it'd be very interesting to you for you to see the actual application of it. And one thing, a couple of things I'll say, and then I'll digress, and Issa can have the last word, and we can give our final citations and stuff, is in terms of the treaty being something that outlined relations. I think that's a broad perspective, and it's right perspective. But within that, the discussion of the application of these treaties and how it applied to the different parties definitely has elements of differences in how these laws are applied to different citizens or different people with different treaties. Specifically, also, I would say it's very important to understand that when we're talking about the mores, the identity, the treaty, whether it gives these particular rights, you gotta really research how it was applied. When you talk about it being restricted to Moors or Moroccans, first we have to understand that in that treaty, it discusses the dominions not subject to the Sultan of Morocco. So the Islamic perspective of it is all Muslims. It was just when the US translated, they put the racial context to the religion and translated it as more. But that treaty actually applies to those who are not subject to the dominions of the emperor. So that brings it outside of just the territorial borders. And just to drive another point home, we've seen that treaty be used outside of Morocco and outside of the United States and the Spanish-American War in the Philippines. When the United States went to the Philippines, they was fighting the Spanish-American War, they ran into some dark melanated or dark-skinned people, and they were Muslim, and they referred to them as Moors. And then what ended up happening is the United States went to the Sultan of Morocco at the time and said, look, we have these Moors here, tell them to stand down. The soldier said, okay, they recognize me as the Caliph out there. I'll tell them to fall back so long as you respect their religious freedoms. So in terms of who that treaty applies to, when it applies, and if it only applies to people that's in the geographic location of Morocco, we have legal precedents and we have historical facts that suggest otherwise. when we see the treaty was actually applied in the Spanish-American War in the territory and the jurisdiction that had nothing to do with both of the geographic locations of those particular countries. But I'll digress at that point. And Issa, you want to have the final word before we close out?
Sure. Thanks, Joe, for coming on with us and having this discussion. Um, there's not a lot of people who actually have the courage to deal with people of opposing views, and it's laudable that you would come on and defend your position in your book and listen to what we have to say, in our disagreement and how we stand on the truth of what we stand on. A couple things that you brought up that I disagree with, but this is the final word on what we say on our position, is that the just sanguis, meaning a child of anymore. The treaty itself never uses the word citizen, and that's very important. It uses the word subject. That changes everything. And the fact that I think Mansa, he had brought up in regards to Spanish American War, it wasn't solely to a geographical kingdom of Morocco as we have today since 1956, but it actually dealt with the Sultan of Dominions. And in the Treaty of 1786 between the United States and Morocco, this is just one of many treaties that deals with the subject of Moors. So I just wanted to reiterate that Moors within the language of the treaty applies to those who are still living today, because the treaty is still in effect today, as you acknowledged. I don't agree that it gives anyone a license to kill or anything of that nature, but I do say that in certain situations, application of treaty to those who identified as Moors, they have standing, and depending on the given situation that they're dealing with, it may come into play if they requested to be done so. If not, it is what it is. But that's all I wanted to say. Thanks for coming on, and thanks for this discussion. Peace.
Okay. And in closing, I just want to again say thank you, Joe. It was definitely an honor to have you on. I really appreciate the discourse, the dialogue, the civility of it all. And hopefully, even though we agree to disagree, we have come to a better understanding of what it is that we may be on the opposite ends of. I think that this is a good step forward for just all Americans at this time in particular, given all of the different things that's going on, to show that we can still have some civil discourse about some opposing point of views and bring our facts to the table. So I definitely appreciate your participation and you coming on, and definitely want to give you honors for that.
Absolutely, gentlemen. I appreciate it. Thank you for coming on. Same thing, my show. I recognize that I go hard at some people once in a while. It's doing a YouTube channel. Part of it's comedy, part of it's shock value, etc. But I respect your beliefs and your positions. I think we just agree to disagree on certain things. And like you said, that it is. But yeah, the conversation, people can listen and do their own research and make up their own minds.
Absolutely. That's always the best thing. People thinking for themselves and doing their own research. Without further ado, I want to say peace, love, and honors to you guys for coming on the show. We'll make sure we tune into some more of your content, and hopefully, you check out some of ours from time to time, and we gain a better understanding. You guys have a good night. Enjoy the rest of your days. Enjoy the rest of your night. Peace out.
Absolutely. All right. Thank you.
All right, good discussion. Peace, guys.